and that's where I'm also going to hit record. So this is where the meat and potatoes of the webinar controls are. So you see me flip back and forth, but that's all I'm doing. So during that time, I'm going to look for if you raise your hands. There's a thing on there, you can raise your hands. Just click on that, and I'll get to you as soon as I can if you've got something wrong or something timely. You can also submit questions, so you can type things in to me or anybody, Andy or the whole class. And also you can answer poll questions as we proceed. That kind of helps us get some input and feedback from you as we're moving through. We're going to try to do a question and answer period after each topic's covered so that we can kind of focus all our time at that point. We'll open up to questions then versus having to stop it continually. But feel free to interact. That's one thing about webinars. It's a little different is there's a little chance for interaction. But just don't be afraid. Don't be shy. We would like you to be engaged and encourage you to interact. So with that, we're going to get this thing going.
So we're going to start out with a disclaimer. This class is intended to educate MPFFU members and affiliate officers. It's intended to serve as informal guidance on the matters addressed and should not be relied upon as legal advice. Anyone using the information provided in this program should rely on his or her own independent judgment, or as appropriate seek the advice of a competent professional in determining the exercise of reasonable care in any given circumstance. MPFFU disclaims liability for any injury or damages of any nature whatsoever, directly or indirectly, resulting from the use or reliance on information provided in this training program. If you ever have any questions about this type of thing, seek legal counsel.
All right, here's our first poll. We're going to show up. Do you feel comfortable with the knowledge of applicable union laws and how to apply them? So just take a quick second and answer that, and we're just kind of see what everybody kind of thinks out there, where you're at, kind of gauge your audience. So do you feel comfortable with your knowledge of applicable union laws and how to apply them? All right, give a couple more seconds for anybody else. All right, so there's kind of where we're at with the class. We've got about 7% that are very confident, 43% most of the time, 36 need a little help, and we got 14% that are totally new to this. So we're glad you're here, and looks like we got a good mix.
So due to the nature and topic of this course, we're going to be going over a lot of slides word for word and then discussing them further.
All right.
And on to poll question 2.
Do you feel your local provides enough information to its members regarding members' rights? So how's your local doing? Do you feel like you could go to any member in your local and say, hey, you've been calling the chief's office, what do you do now? Or, hey, the union heard you guys talking about the contract and said don't talk about that at work. Do you kind of know if your local in general does a good job with this? And it can even be as a union as a whole. Do you think we do a good enough job? That's one of the reasons we're here today. So go ahead and type in something real quick. Just give a couple more seconds. Don't waste too much time on this. All right. Here's the results. So only 17% feel that you do a really good job with that. A quarter of us say no, but most do anyways. And over 50% say we need to do a better job. So that's kind of telling right there. We need to make sure we're passing this stuff on and make sure everybody gets the information. So
the objectives of the webinar today is to understand some of the basic rights firefighters have, understand how and when to assert these rights, and to understand where and how we gain these rights. So we're going to go over a couple things, a brief history of unionism. We're going to discuss a little bit the National Labor Relations Act, PARA and Michigan Public Employee Relations Act, Public Act 312, and we're going to go over Weingarten, Garrity, and Loudermill. Most of the Union history is covered in member orientation class, in the Union history class. State Union Education and Training Committee puts out those classes occasionally, so you can check out the State Union's website to find out more information about those classes and when they might be presented.
These classes all kind of intertwine, so they kind of, you'll see a little bits of pieces of here and there of the different classes because they all kind of meld a little bit.
So we normally would play a video in here, but due to bandwidth issues, it generally turns out pretty poor. So we'll talk a little bit briefly about the Triangle Factory Fire of 1911. There's a great video on here, and you can search it on YouTube. It's about 20 minutes, but it's a very, very good video. This is kind of where modern unionism started in the U.S. There's a factory in New York City. Women and children worked sweatshop type conditions, and they were management was concerned about stealing and workers leaving work or taking inappropriate breaks and things like that. So what they did is they actually chained workers in on the floors that they worked, and there happened to be a fire. Someone threw a cigarette butt into the garbage can. They thought it was out, but it started a fire. And unfortunately, hundreds of 146 people died in the fire. But none of them could get out. They'd jumped out the windows. The fire escapes were inadequate, and management all got out from their floor, but they failed to unlock the doors or unchain the doors and let all the workers out. And that really, New York City with the deaths, and it really kind of started a strong movement towards unionization in the U.S. And again, I encourage everybody to find that video. It's about 20 minutes, and it provides some real good information.
Interestingly enough, they still mourn and have a ceremony every year to mourn this fire still, and it's just over 100 years ago. We're not talking ancient history. That's the interesting thing about this. This isn't anything crazy. This is not that long ago, and then FDNY still puts up a ladder to the 6th story every year, and they do a whole ceremony symbolizing that they can only reach the 6th floor with the ladders and trucks of that day. So kind of interesting.
And most of the people died above that level.
Sorry.
Oh no, all good. All good. So starting out of some of that type of environment, the National Labor Relations Act was passed. This is 1935. FDR signed an act giving workers a right to form unions and negotiate contracts. Around that time, a lot of different laws were being passed: worker rights, worker safety, and prior to that, sweatshop conditions existed in great numbers, and this helped to improve working conditions and wages.
One thing in that video they talk about, Andy, that's interesting is still during this time period, they had something called sweatshop task forces still in their government. I just think that's crazy. You're talking the 30s and 40s. They still had something called sweatshop task forces to raid some of these factories that were still having just horrid conditions comparable to the Triangle Factory fire, even 20, 30 years later.
So the NLRA gave the right to collectively bargain. It allowed for collective action or concerted efforts such as strikes. This is a strike ensued after the Triangle Factory fire, and the Act actually allowed for that strikes. NLRA provided for a list of actions that constitute unfair labor practice, and this was a federal law. Provided elections, creating exclusive representatives, like how we see today. We have bargaining unit representatives. This was the very, very first underpinnings of such a thing. Unfortunately, the NLRA had no teeth to make the employer meet the obligations in the contracts, or even force them to talk in the first place. But this was the beginning. You got to start somewhere. This act created basically collective begging. And unfortunately, a lot of worker groups were not included, including government employees, rail people, airline workers, that type of person, that type of job. But and just like everything else, you got to start somewhere, and this was the very underpinnings of some of the rights we have today. Looking at Michigan in specific, Hutchinson Act was passed in 1947. This provided for non-binding mediation of contract disputes and prohibited strikes for public employees. It imposed very stiff penalties and fines for someone organizing a strike or even a concerted work effort, like sick outs and that type of stuff. And this applied to public employees in the state. It was amended in 1965 to exclude some of the very stiff draconian penalties that the Supreme Court upheld, including termination, loss of benefits, jail time, and fines. The court held that a public employee had an obligation to provide civil services and had no right to strike. So in effect, back in the 40s, 30s, public employees were servants. We were almost slaves to the government. It was definitely a weak law, but again, just like everything else, it was an improvement on the act before it. So then we move on to PARA in Michigan, Public Employees Relations Act. As unionism grew in the state and in public employment, in 1965 this bill was passed. Provided for recognition of union representatives and forced the parties to bargain in good faith, protected union members' rights to union activities, and provided for unfair labor practice. The State Firefighters Union was called the State Firefighters Association at the time. General Counsel Ted Sachs was instrumental in getting this bill passed, or even drafting it. At this time, 1965, the MPFFU had grown to about 60 locals in the state. Many of you hear history. Dan Delgado, he has stories. He was Mr. Delgado started in Detroit, union president, became state union president, district vice president for the International, and ended up working for the IAFF in Washington, D.C. for quite some time. But he tells stories. He lived these times, how cities fought hard against getting this law to pass. They wanted control over everything and not to have their workers have rights. Ron Halveston, who still practices law in the state for unions, was working for Ted Sachs at the time. Sometimes if these guys show up at a district meeting or something like that, you can talk to both of them and ask about their experiences back in the late 60s. PARA also defined what constitutes a strike and created penalties for it, provided for mediation, which is something we didn't have before. A third party can come in and try to get the two parties to come to a conclusion. Provided for MERC, the Michigan Employment Relations Commission, a budget. So basically, PARA requires that you file you got to file 60 days before your collective bargaining agreement expires.
Real quick on that too, Andy. That change in status form is real easy to find on MERC. So a lot of people are like, think that, I have to have my attorney do it or whatever. If your attorney wants to do it, if you're working with an attorney, that's fine. But you can file that change of status form. And when you do that, it lets MERC know that you are starting to bargain. But then it also assigns you your mediator as well, which is kind of good to know. A lot of locals I deal with, sometimes they don't do this, and then we get to an impasse or we get to a point where we need help from a mediator, or we need to go a different direction, and they haven't done this yet. And so then there's kind of a delay to get that done. So that status form change, I know it's on MERC, and it might even be on our website as well, a link to that. So it's just called change in status form.
Yeah, and typically as we work, my locals had a pretty rough time with negotiations lately, as have a lot. So we work close with our lawyer, and we just ask our lawyer, say, hey, here's some of our proposals, let's review this stuff, and they file the form for us. Not that it's a big deal, but they've got it sitting on their desktop, so it takes our lawyers 10 seconds to type it in and send it off. PARA also made it legal for public employees to join and form a union. Protects concerted effort, including negotiations and bargaining. Prohibits discrimination by employers towards union members. Provides for collective bargaining of wages, hours, and conditions of employment. Provides exclusivity and an individual right to grieve. Provides for fire officers below the administration to belong to a local. So everyone except your fire chief can be in the same local. Some places it's not like that. There's different locals for officers and different locals for firefighters, which can cause a conflict and problem amongst even members in the same place. Provides for election for certification of a local, establishes permissive subjects of bargaining, provides for unfair labor practices if para is violated. There's a lot of public school specific language in there. So naturally, with all these positive union things, cities did not want to abide by para, which caused some significant problems. Blue flu, Lansing firefighter strike, Pontiac strike, Kalamazoo lockout. A lot of these things happened after para was signed. Para guaranteed that the employer had a right to talk to you. It didn't require that an agreement would result, though. Strikes and blue flu were prohibited by law. There were strikes in the city of Lansing and the city of Pontiac. A lockout occurred in Kalamazoo, and the firefighters walked off. So one important thing that happened there was the Portage local wouldn't cross their line to fight fires during a lockout. So everybody recognized that this was a significant problem because you can't, municipalities need to have fire protection, and a labor dispute shouldn't prevent that from happening. So 2 years later, Public Act 312 was passed. Public Act 312 of 1969 was really the end of collective begging in the state. This is the law that provided binding arbitration to resolve contract disputes. It's only been enjoyed in the state since 1969. A lot of us, started much later than that and take it for granted. Unfortunately, it's always under attack. Even now, we've had to go to Lansing to fight the full repeal of PA 312, which happened just a few years ago, and fortunately, we're able to get 312 just modified. Made some concessions, but we still enjoy the protection. There's still 70,000 IAFF firefighters in the U.S. who don't have this right that we have under Public Act 312. Teachers at the time opted out. They felt the ability to strike would be more beneficial than having a third-party arbitrator decide a contract in contract disputes. Unfortunately, now they wish they had it. Governor Engler gutted the law para in 1994 and made it illegal for teachers to strike. So now they don't have 312, no way to settle their disputes, and they can't strike either.
Yeah, they're kind of back where we were back then, and unfortunately, they've been the chosen one lately to just get beat up on in Lansing. One thing I really wanted to hit on that Andy talked about was and share with your members is that point about the 70,000 IAFF members that still don't have this. I mean, we've had this since 1969. There's still firefighters across this country that do not have any form of binding arbitration, and they're basically stuck. It just creates huge issues with their labor force, and they've really got nowhere to go. They can't strike in most cases, and then they have no way to get any kind of binding arbitration. The biggest kick in the face is a lot of these mediations, like Andy talked about a little bit ago, a lot of these mediations have no teeth in them. So you're literally having a mediator coming in saying, yep, firefighters, you should get that big raise. You should get better, more time off. You should whatever. And then without binding arbitration, the cities are like, yeah, that's great. The mediator says that, but yeah, that we don't agree. So we're not going to do it. So, I mean, so how pissed off would you be if you actually won a mediator, or a mediator came in and gave you the decision you wanted, yet it still didn't matter? So you can just see kind of how upset the firefighters got during that time. Real quick, we'll show you this picture of the gentleman responsible for getting Public Act 312 taken care of. I think there's Dan right there. Governor Milliken signing it. Governor Milliken is a Republican out of Traverse City that signed Public Act 312, realizing that we needed peace and harmony amongst our public safety, police and fire across the state. Real quick, take a second if anyone has any questions up to this point. Simply just raise your hand, or you can type them in there as well. You can also chat if you'd like. Any one of those mediums. Does anybody have anything for the good of the order? All right, we'll keep plugging away. And go ahead there, Andy.
So, right to work, Michigan became a right to work state. Granted, police and firefighters were carved out of this. Uh, but unfortunately, right to work isn't a positive right for workers. There was what's called Beck rights. Supreme Court made a decision years ago that said a person doesn't have to belong to a labor organization. Free speech rights were the theory behind it. And members were allowed to withdraw from the union, and they'd have to pay the union a service fee to enforce the contract, to settle grievances, that type of stuff, and that those non-union members that were part of the bargaining unit had to pay that fee. What Right to Work does is allow those workers who don't want to be part of the union to not pay anything. So, in effect, while you have a member who doesn't want to be or you have a person in your bargaining unit who does not want to be a member of your union, they can opt out. They don't get all the benefits of union membership, classes like this, the stuff your local does. They don't get to be a part of that, but they still have to pay for contract administration. They got to pay their fair share. It's called a fair share fee. If you're a right to work state and right to work laws apply to you, which could potentially happen to firefighters and police officers in this lame duck session, those members no longer have to pay for that contract. They become free riders. So you have uh, people who you're required to represent. They apply to your contract. They have to follow the provisions of your contract, but they don't have to pay to help it. So uh, you can see how that would create a financial burden on everybody else. And all it does is help divide the place against unions. Collective bargaining, there's still areas without collective bargaining local to us, even in the 8th District, the IAFF. Indiana, Kentucky, Tennessee, and Kansas are local areas that are close to us that still don't have the right to collective bargaining. 16 states in the U.S. are non-collective bargaining states. Basically, the city, township, municipality, whoever it may be, says, here's your contract, live with it. Some locals have the right to bargain, but they don't have to reach an agreement. Jackson, Mississippi, Local 87 of the IAFF, went 88 years before they got their first contract. And there's many other locals that don't even have a contract yet.
And really quick, the reason why on this slide, right to work and collective bargaining are on the same slide is a lot of people put those together, and they're very different. So right to work is just draconian, horrible law that's obviously creeping its way here in Michigan. And collective bargaining is the right to be able to sit down and bargain a contract with your employer. So just keep that in mind. A lot of people get those kind of mixed up. They do fall hand in hand a lot of the time. A lot of the right to work states happen to be non-collective bargaining states just because that's kind of the way they are. But do keep that in mind that they're kind of pretty different, and our members need to know that as well. The right to work things could jump up again for us in Michigan. I believe they carved us out. There's a decision that the Supreme Court made this past summer dealing with a teacher in California that didn't want to pay her fair share and took it all to the Supreme Court. Well, Justice Scalia passed away, and his untimely death leveled out the court. And so when they heard the case, they ruled in favor of the union and upholding that the unions could collect service fees and collect fair shares. If the teacher would have won that, that would have put a national Supreme Court decision, basically in effect would have made all of us right to work. So unfortunately, that's the way it happened. But for the unions, for now, we're kept away from there. But now that that's done, the national right to work push basically lost their champion. That was the thing that they were pushing to get through to basically make the entire country right to work. Now they've lost that, so they're going to be back on the attack wherever they can to pick off states one by one or find another case that they can hopefully win. So nasty stuff. At the end of the day, it's just to break unions. That's all it's about. Nothing more. Check for questions here. Hey, same questions. Monty asked about if there's an update for House Bill 5829, which allows for independent bargaining, and I'm not sure if there is an update. I don't have an update on that. I know they're always trying to chip things away and make things more difficult. And it's funny, they want to give local control on some things and take away local control on others, and this is a good example of that. But I don't know, Monty, you want me? I'm going to open up your mic and let you kind of hit on that. Let me find you on here. There you are. Monty, you there?
Yeah, can you hear me?
I can.
Okay. I was just at a lobbying session with the AFL-CIO, and that was one of the things that they're keeping an eye on. And basically, what it would do is allow somebody that chooses not to be in your union that opts out to go ahead and bargain their own wages independent of the local representation. And so,
No,
just another way for them to undermine the unions, and they're keeping an eye on it. They don't know that this might be one that especially if we lose or they lose the House, all bets are off and could try to move forward during lame duck. So it's always important, for our membership to keep an eye on the legislation that's out there and reach out and talk to their people on it. But I haven't seen any movement on it since it was last up. I didn't know if anybody else had.
No, I hadn't heard any more about that at all. And there's always stuff like that in Lansing that's getting touted, so people that aren't there as much. But Monty makes a good point. There's stuff that's constantly they're constantly trying to mess things up. The interesting thing about that too is back in the day, and that's what's funny. We kind of lose some of this history. The businesses liked exclusivity just as much as the unions did initially, because there'd be large factories that might have to bargain with 50 different entities. Some might be a single individual. There could be 4 unions in the same shop, and they've got to negotiate a contract with each one of them. And then maybe there's 10 people that don't want to belong to a union at all, so they got to do them all individually. There's another group over here. So I mean, the corporations liked exclusivity just as much, especially initially, because it caused. I mean, can you imagine having one shop having to negotiate with 50 different entities? I mean, it'd be a full-time job, and then you're constantly, you know, doing a one-up thing. It's almost like baseball players. You're constantly you're contract with each individual one, so you're constantly dealing. So the corporations like that as well. So, anyways, that's good stuff, though, Monty. I appreciate it.
Yeah, thank
Anthony,
you, Monty.
yeah, Anthony, I'll chime in. You good?
Nope, that's good. Thank
Okay,
you.
thanks. Bye. All right. All right. Any other
Ooh, poll
questions?
question.
Yeah. Any other questions about what we covered so far before we start going into the poll? Good. All right. Do all of your members know when, how, and who to contact if they need a union representative? So if you went in any one of your stations and said, "Hey, Chief wants to talk to you in the office," and he's pretty pissed off, do most of your members understand what's going on and know what they need to do to get a union rep in your shop? And these are all anonymous too, so we're not keeping track of this stuff. So just giving it a couple more seconds, and we'll close the poll. All right. Thank you for your input. All right. About 30. So that's kind of not quite down the middle, but obviously there's over half of or no, but most do, or no, we need to do a better job. So again, that comes back to we talked about earlier, is making sure. I mean, having 10 classes like this, or bring stuff back from these classes and tell these guys, what they need to do, and put the onus on them if they need to get help. Kind of share that information. I got a question here. Okay, I get that. We are recording this, so it's being recorded. So if somebody had a question, if a call came in or something, if they're doing it at the station, would they be able to pick it up later? We are recording it. We haven't recorded one yet, so we'll see how this comes out. But we're hoping we can record it and then push that out, and you'll be able to hear it then. So, all right.
Okay, next section we're going to talk about is your Weingarten rights. Weingarten was a case that was settled by the National Labor Relations Board in 1977, gave the employee a right to union representation in a disciplinary case and defending their conduct. So basically, the case was about a business who operated a chain of food outlets. There were two types that they operated: lunch counter and lobby food outlets. One provided a free lunch and the other did not. Leora Collins was a worker. She worked at the free lunch job for 9 years when she was transferred to a job that did not include a lunch. In the new job, she was reported to have been stealing money from the register. Store manager hired a PI, which watched her for 2 days and found nothing. At that point, the store manager told the PI that another employee told him that she had not yet paid for her lunch. The manager and investigator summoned her and brought her in for questioning. She asked for but was denied a union representative. She said in her testimony or questioning that she'd put $1 worth of chicken in a $3 box because they were out of boxes, and another employee confirmed the story. Now, mind you, this was, they were investigating her for stealing food from the employer. At the end of the interview, which with a PI and management was pretty intensive, she broke down and told them that she had taken some meals for free. Throughout the investigation, they found that all the employees had, because the management's policy was very confusing, even though corporate headquarters was unsure of the actual policy for free food. Although she continued to ask for a union representative throughout the interview, she was denied. Once the interview was over, she immediately told her shop steward about the incident, and an unfair labor practice was filed with the National Labor Relations Board. The National Labor Relations Board and finally the Supreme Court of the U.S. ruled that under Section 7 of the National Labor Relations Act, the employee has a right to union representation if their job might be in jeopardy. The Supreme Court reasoned that a single employee faced with discipline may be too fearful or inarticulate to relate accurate events dealing with potential discipline. And definitely in this case, where you've got a private investigator as well as management sitting across the table grilling an employee, that's the case. A knowledgeable union rep can assist the employer by gathering facts to get to the bottom of the issue more quickly. They can clarify questions. They can calm the employee and help them in their answer. The NLRB has extended the right to non-union employees, but as recent as 2007, they've ruled that the right only applies to union employees. So there is some back and forth about this. At the end of the day, if you have a member who's called in for discipline, they need to know that they always need to get a union representative. Representative is an active participant. Merck has ruled in the City of Saline ruling, grabbing one little piece of the actual Supreme Court ruling that says the representative is present to assist the employee and may attempt to clarify facts or suggest other employees who may have knowledge of them. The employer, however, is free to insist that he is only interested at that time in hearing the employee's own account of the matter under investigation. New Haven ruling for written statements. New Haven ruling states that the union has the right to see and be part of a written investigation. Employers have been using this technique to get around union involvement for quite some time. They ask for everything in a written statement. Even in a written statement case, Weingarten applies.
That's a big thing. Oops, I'm sorry, Andy. That's a big thing. That's a big thing across the state that I've seen, is instead of having these meetings nowadays, because everything's emailed and we're in the age of technology and communication and all that, that they say, oh, hey, Tommy, just shoot me a quick email and let me know what you did yesterday when you went over to the convenience store. They said you guys, they thought you guys took something or whatever. And rather than, actually having an interview, you're asking people to write down. And when people write down things, they generally write down everything. And we really tell people in these interviews, you need to answer questions and give the facts, but you don't need to just tell them, what happened that entire day. So if you have a management that does that or administration that does that, make sure your people know, your members know that they need to run all that stuff through the union. I had a local the union, or the chief rather, asked for all these written statements condemning this one member who'd kind of done some not the best things, but overall wasn't that horrible of a member. And all these guys were kind of mad at him. It's more of a personality thing. So the chief's like, "I'll just write these statements. They're just between you and me." Well, then they end up demoting this guy based on some of these letters. And guess who was in front of that member testifying at the arbitration hearing? Every single one of those people were up there reading these scathing letters about this person right in front of them. And there's nothing, nothing's between you and me, or nothing's secret, especially in public, the public environment. And if this thing goes to arbitration or something like that, all that stuff's going to come out as evidence. And, you could be put in a spot you don't really want to be. So there's definitely a lot of stuff out there to deal with all these things.
At the end of the day, there's also, the part of having a union representative in there is to avoid a he said, she said type situation. Your management or fire chief calls you in for questioning, and you give your account of facts without a union representative present, and the fire chief takes different notes and uses that and says, well, no, that's not actually what you said. With the union rep in there, your union rep's going to be taking notes, and you'll have backup for your factual events. And additionally, a disciplinary case, even if it might be minor, you'll understand that the management has a right, or has a right to question you, but they have to be fair and uniform in their discipline. If your union representative says, well, one guy, he pick anything, something minor, forgot to close the garage door after leaving for a call. This guy, he just got a verbal reprimand for it, but management wants to suspend somebody else for it. The union has to be there to make sure that management is treating everybody fairly and equally.
And really, the main person there this whole time is the union. The union's going to be there to protect the contract and protect the members, and the union is the only one that's consistent. Members are going to come and go. The union's consistent and kind of knows what they've dealt with in the past.
And the way it should look when one of these situations arises, management says, hey, so-and-so, I need to have a meeting with you. That member should say, hey, is this something that could lead to discipline? And if management says yes, say, all right, well, I'd like to have a union representative present. And if you got a good management relationship, management will say, okay, no problem. Schedule your meeting, get your union representative, and that representative is a representative you pick personally, not one picked for you or the one that's most convenient. That union rep should take the member about to be questioned aside, have a caucus before, and say, hey, what's going on? Get information, discuss it. And one thing to remember is there's no union rep member-client privilege like there is with a lawyer. If a member tells a union rep something, they can be forced to testify to that as well. Your union rep, and I'm assuming most of you are at some point going to be union reps, which is why you're taking these classes, understand management has the right to question an employee and tell your members to say, look, you just only answer the question, don't volunteer information, and you have to be truthful. You can't lie to management.
I've got a quick question here, Andy. Kevin, I'm going to turn you on here. And he's not connected to audio. Okay. Kevin asked, we've been asked to do, I'll ask this to you like I'm asking from him, Andy. So Kevin wants to know, we've been asked to do daily logs and submit them to our captain. Is this a bad idea? I guess it depends what's in the logs, right?
Yeah. That's a tough question. If management's asking you to write down every individual activity, Joe got up and cooked breakfast, Joe got up and mopped the floor, Joe took a 10-minute break, it's probably a bad idea. Some places do keep a log of daily activities. We get our station duties done, bathrooms are cleaned, checked out the engine. So it depends on the motivation behind management, really, why this could be a good or bad idea. If management wants to say for the purposes of, all right, yeah, look, we had a vehicle accident, but I can show you through our daily logs that our guys check the vehicles out every day. They're doing a DOT compliant morning check. Tires are good. They verified this. That's probably a good thing. But it really depends on the motivation behind it, and that's what you got to figure out.
Yeah, for sure. I really like to on that. Just so you know, you guys have some handouts. There's a few handouts here. They're down here. There's a city saline, that saline ruling, the Weingarten. So that's kind of a cool thing to read. There's also member rights, kind of talks about all these things we're talking about. So it's kind of nice to you can kind of take a look at that and see what those things are. I've got another question here, I believe. I'm gonna have you keep going here then. Any other questions about Weingarten?
A couple last points I'm gonna make on Weingarten. As a union rep, tell your members only answer the questions. Don't get into these long drawn out stories. If you can answer a question with a yes or no, that's better. Answer the question to the best of your ability. Be truthful and don't volunteer extra information. Just answer the question that's asked. When I was union steward and president and was dealing with these things all the time, there were some people that just liked to talk and dug themselves holes because they got off subject, talked about different things, and frankly started other investigations that shouldn't even have been started when the question was, were you on duty on this day? It's a yes or no question. So keep your questions brief, or keep your answers brief, truthful, and concise. Next, we're going to talk about is Garrity. Garrity rights were a result of a case, Garrity versus New Jersey in 1967. I believe it's the Fifth Amendment protects from criminal prosecution, prevents a right to self-incrimination. This resulted protection from criminal prosecution during an internal investigation. When you're questioned, you must be truthful. You could face internal discipline for your conversation facts given. Unfortunately, you could also face internal discipline for insubordination if you refuse to talk. This came about out of Fifth Amendment violations, right to self-incrimination, and this only applies to public sector employees because your employer actually is the government. So you've got a right to not incriminate yourself when being questioned by the government. Case history was in 1961. 6 police officers in New Jersey were accused of ticket fixing. Edward Garrity was one of the officers. They were interviewed and told that their statements could be used in a court of law. While they did not have to answer, however, their jobs were in jeopardy if they did not cooperate. They answered to questions incriminating, which led to criminal charges. They appealed all the way to the New Jersey Supreme Court, which ruled in favor of the officers. The court found that officers were compelled to testify against themselves under threat of losing their jobs. It's coercion and violates the 14th Amendment due process clause, as well as their Fifth Amendment right against self-incrimination. So, in effect, what your Garrity rights provide for is, while your employer is a government and you need to, management has a right to interview and question you, if you exercise your Garrity rights, the questions you answer can only be used for internal discipline and cannot be used in criminal prosecution. In my case, in my local, I've had to exercise someone's Garrity rights once. It turned out to be nothing, but the management said, if I find you guilty of this, there's potential that criminal proceedings could occur. And I said, all right, well, I'm going to stop you right now. I'm going to exercise this member's Garrity rights. So you understand you have a right not to incriminate yourself for criminal prosecution. However, you do have to answer questions that could be criminally prosecuted. And exercising your Garrity rights protects you from criminal prosecution when you're participating in an internal investigation.
And keep in mind too, some things can sound innocent enough and non-criminal, but even something as simple as, hey, you're paying people for trade time or something. Well, they could get their way around that and maybe try to take you to court for fraudulent activity or defrauding the city of money or however they want to do it. But something so simple as that. So you get guy and say, yeah, I'm paying guys $20 an hour to work my shifts for me. Just kind of be like, yeah, that's nonchalant and whatever, a little discipline. Well, they could try to go after him criminally for that. So just kind of keep that in mind that it's more than just the cut and dry. Someone came to work with weed in their coat and somebody found it, and that's obvious that could be criminal. So just kind of keep those things in mind when you go through. But there's a Garrity form. There's really good Garrity stuff on the website, and there's a Garrity form, I believe, in your handouts here as well. Now, where it's not required to have a Garrity form and sign it, as long as it's stated in the meeting, we really encourage you to have a form, and I believe your counsel would say the same thing. Just better to have it signed, that way everybody knows what's going on with that.
You're going to run into cases where some managements may refuse to sign anything, and there's nothing you can do about that as long as your union rep's taking notes and puts clearly in the notes, at this time we exercised member so-and-so's Garrity rights. Put it in there once or twice, make sure that management acknowledged it, and that's the best you can do sometimes with a hostile management situation.
Yeah, and you literally just put something on there, and like you said, just that they refuse to sign it, and everyone else has signed it, and that should be good to go. That's unfortunate.
Hopefully most labor management relationships in the fire service are not of that caliber, but unfortunately all these cases came about because of labor management relationships. Last one we're going to talk about here is Loudermill. Give you a case history of this guy by the name of James Loudermill. Was a security guard for the Cleveland Board of Education. He was terminated without a hearing for not disclosing a prior felony on his job application. The main issue that was argued here is some civil servant jobs where the employee has tenure, the employee has a private interest in retaining the job. It is looked at as property. That said, the employer has an obligation to give the employee due process, including a pre-termination hearing. So basically what this requires is that before discharge there's a notice and an explanation of why you're being terminated. You get an opportunity to present your side. Unfortunately, courts tend not to reinstate people because of this. A typical case would happen is someone would file an unfair labor practice charge, and I'm referring to here in Michigan, that their Loudermill rights were violated. Merck would say, yes, your Loudermill rights were violated. They would go back to management. Management would say, all right, go ahead and give your case. And they give their case and present their case, and at the end of the day, they're still fired. So, well, it is good to know. It doesn't have a whole lot of teeth, but it does give you at least an opportunity to present your side of an argument in case of termination.
Any questions up to this point about those? Any questions? Good to go. Okay, we got another poll question coming up. Who should your local contact as soon as possible if a local leader is punished for his union activities? Give you a couple more seconds to answer. All right, I'll close the poll. Share results. Really, this is kind of a trick question because it really is going to end up being all these people. But at the end of the day, you need to make sure that IFF is involved somehow. They're going to want to be involved on the ground floor of any type of a thing like this. So yeah, you can start with your VP. That's a really good answer there, your state VP. They're going to get and let your local attorney know as well. They're going to go through your IFF district VP because he's going to want to know, and then they're going to get IFF legal counsel involved as well. And then IFF legal counsel generally is going to work with all of those people through the process, including your local attorney, to take care of that local leader. So just make sure we do that right away. That's key. The IFF doesn't want to get in on the 10th floor. They want to get on the ground floor. So if something's going on with one of their leaders and they want to be involved, they want to make sure you have the resources right from the get, not halfway through the process. So make sure you let people know. Don't just go it on your own. And like I said, it's a good question, but it's kind of a trick question because at the end, everyone's going to be involved, but you need to make sure IFF legal is involved from the very beginning.
And, Michigan Professional Firefighters Union District Vice Presidents are all field service reps. So they'll get the IFF involved, as will the IFF District Vice President. DVPs are probably going to talk to you briefly, forward an email on to the IAFF legal counsel, and you'll get an email or a phone call from them within a day or two. The IAFF is on top of it. So here's protecting our rights. The IAFF protects the First Amendment rights of firefighters to speak out on issues affecting firefighters and the public. I see here a newspaper article. It's from Arkansas. City Board reinstates firefighter. The basic concept here is that union leader was fired for speaking out on his rights. IAFF got involved and got the guy's job back. So we look at this, and this is kind of, a little bit closer to me. Not that I'm from Arkansas or anything. I'm Harrison Township, Metro Detroit area, Macomb County. But we have this exact case going on in a community that borders mine, Macomb Township. They have their union president and union vice president have been fired, and both have been off the job for almost a year for union activities, participating in union activities and advocating for their members. Both guys are fired. They've been without pay, without a job. My local president, Matt Sarr, who's also the district vice president and an IAFF field service rep, he was involved immediately right in the beginning. Got these guys covered under the IAFF's Guardian policy. So right now, getting involved early, IAFF was involved right from the beginning and was instrumental in working through this case. They're still waiting on their arbitration cases, but there's about a 99% chance they're going to prevail, get their jobs back, and be back on the job. So when we look at this and say, Arkansas, nothing like that could happen here, understand it is happening here. It's happening near us right now.
Yeah, there's another one recently up in my district where a local was trying to organize, and the 2B local president had different penalties placed on him for speaking out and trying to organize. And the IFF came in. They weren't even a local at the time. As a matter of fact, they're just they're going through the process again now and working on their first contract, thank goodness. But they actually penalized their union president trying to organize an IFF local, and the IFF came in and spent a great deal of money fighting for this person and getting them made whole, which they did. Ended up being kind of a bad thing, because at the end of the day, if you fight with your city, what's going to happen? It's not going to be the best workplace down the road. So they ended up getting a settlement, but that's they were there, so that wasn't even a fully instated member. That was a person that just wanted to be an IFF member, and they were fighting. So you can just imagine what they do for your leadership and your local president, vice president, things like that are standing up for our members.
Now, in this specific case that we're looking at here in Arkansas, this is a local president who was passed over for promotion 3 times, and then he was fired because of his work in union activities. He'd given a speech at city council meeting because he was concerned about the loss of tenured firefighters in his community, people with experience and time on the job. The IAFF's legal team fought for him to be reinstated and made whole. His case wound up in federal court. The jury awarded him more than they had asked for in addition to his job back. His statement was, "If it weren't for my brothers and sisters at the IAFF, I would not be where I am today." So, there's 2 cases here in Michigan that Sean and I both just talked about where these things are going on around us. And, we kind of get focused on what we're doing and lose sight of the fact that there's people close to us, communities that are close to us that are that hostile to their firefighters. So at the end of the day, get the IAFF involved early in cases like this. They need to get involved right on the ground floor, like Sean said.
Any questions about that before we move on? Good to go. Okay.
So one thing we always like to include in these classes, member orientation, this one, part-time firefighting, or why are we against it? So destroys the collective bargaining process. So, one of the arguments is you sit down in negotiations, your negotiating team meets with city council, and council says, well, why do you guys deserve raises? Well, we're firefighters, we come into work, we do the job, blah, blah, blah. You get the whole 30-minute conversation, and they immediately destroy it by saying, well, you've got 5 of your guys doing it off duty for free. So why do we need to pay you or pay you more? Death or injuries. We've got some laws in the state, cancer presumption, which just passed, Heart and Lung Act. Now, these things are very firefighter specific. So if a member develops a specific cancer while on the job, it's presumed to be as a cause of job, line of duty injury. So one of the arguments used to destroy this for people to volunteer is, well, how do we know that he didn't get this job in his volunteer job, or this cancer on his volunteer job, or this injury on his volunteer job? He just came in here because he's got insurance. So that's a means to protect yourself. You can say, no, I don't volunteer off duty. I'm a full pay professional firefighter. That's what I do. And you can cause a direct line of communication or direct line directly to where this came from, this injury, illness, whatever it might be. And additionally, it helps full-time departments hire other full-time firefighters. Neighboring local, or your local where you live, may not have all the full-time firefighters it need because it's got full-time firefighters volunteering off duty. What if your fire department, the one you work for, hired all volunteers? They could get people to do it. So, hey, we'll go to a volunteer department. There's your job gone. And do they have volunteer police departments? No. At the end of the day, full-time professional firefighters were better trained, better equipped, and we do the job better than the volunteers do. And that's what we need to keep pushing forward. We need to show this, and every time we have one of our members volunteer, it weakens all the rest of us. Bottom sections there are parts of the Constitution and bylaws of the IAFF, rival organization stuff.
And right down here at the bottom hits on the exact part where it kind of impacts, goes against the IFF. This is where such job is within the work jurisdiction of any affiliate or which adversely impacts the interests of any affiliate or the IFF. Pretty much if you volunteer, you're adversely impacting your own local and then subsequently other locals. Because if let's say I'm a 6-person local and 5 of my people are volunteering, so our city decides not to give us a raise because we're willing to work for, $10 an hour on my days off, and so why do I need to get a raise? So they win that argument, and how do I fight it? Well, next door, I'm a comparable with next door. And now they're like, hey, why didn't you guys get a raise this year? We're trying to get a raise, and they're not going to give it to us because they said you guys didn't get a raise. Oh, well, we didn't get a raise because a bunch of our guys are doing the same exact work off duty for half the price. So they felt that if the public knew that they shouldn't be paying us as much. So I mean, it does adversely impact everybody. It's not just a thing about trying to tell you what to do or the union's telling. And the funny thing about the union is this: we're all the union. We all agreed with this. We all put forth this Constitution and bylaw amendment. So we see what this does. In non-collective bargaining states, it's a little different. That's a lot of the ones that push this. But in our state, that definitely does impact not only your local, but locals around you. Any questions on that point?
Yeah, one more comment here. This local that I was referring to, Macomb Township, where their union president, union vice president are terminated. Our district vice president and other members have filed charges against full-time career firefighters who were volunteering at Macomb Township. Dozens of them. So if we've got these dozens of firefighters there with experience and knowledge, why does Macomb Township need to hire full-time firefighters? Well, because they're a 90,000 person community covering 30 some odd square miles, and they staff with 6 full-time firefighters.
Yeah, there's
a perfect
horrible
example of volunteering destroying what could be a strong full-time union fire department. And everything goes along with it. Your union administration, your president, vice president losing their jobs. So in closing,
poll real quick.
One more poll. There we go.
Do you feel like you are better prepared and informed in regards to member rights after this session? Again, we covered a lot of stuff in a very short amount of time, but we really tried to keep it simple. That's the whole point of these webinars. We don't want to keep you on here for hours upon end listening to Andy and I talk. So we kind of want to just hit our points and And there's areas in the evaluation at the end of other stuff. If you put in there, for example, no, I could always learn more. Put in there what you'd like to learn more about, if there's anything in there. And I kind of, that's kind of a trick question a little bit, because we can always learn more. But we hope you learned a lot and you picked up some good things, and that's what we want from any class. Even if you pick up a couple things, and remember, don't share those things. And so yes, we got 89% of you learned a lot, and knew. So we got everybody. There's a 0% on you knew most of this before, so that's good. So I'm glad you guys picked up some stuff.
It took me 20 some odd years and being involved in the fire service and being involved in my local to understand most of this stuff. So it's important. Some of the things you can do is always know your CBA, your collective bargaining agreement, and your union's constitution and bylaws. Who do you go to if there's a problem? Who's your union rep? Who's your steward? And know your rights under the various laws and how to assert them. Make sure that while you know those now, or at least have a good overview of them, make sure the other members of your local know them as well.
And at the end of this, we kind of always wrap up. I always tell people that, hey, if you like this class and thought it was a really good thing, you picked up some good things on it, tell some members in your local the next time we have one of these, say, hey, this is a really good class. You pick up some stuff. It's really good. Go ahead and sit down on it, sign up for it. If this is horrible and it was the worst hour of your life, then just go back to Firehouse and tell the person that you can't stand on your shift, and make them sit through it as punishment. So, but say that in jest. Make sure you're sharing this information with people. Get them online, and this will be recorded. So I'm hoping that comes out well. And I'm not sure how we're going to share that yet, because we're kind of new to this. But there's evaluation forms at the end, so please be frank on those, and make sure that that's how we build our programs. That's how we improve these programs. So if there's something we can improve, put that on there. There's plenty of areas for you to give your feedback, and then we'll let you know right now. Is there any final questions? I got Kevin here. He's got one. He can't talk. So, okay, he's got that on there. Good. Any other questions from anybody before we close this thing out? Our emails are there, and there's also going to be follow-up emails. So please fill those questionnaires out. It is very helpful for what we do. And our emails are there, and they're also on the webinar. So if you want to ask us anything afterwards or get in touch with us, our stuff's there as well. And thanks for attending. Go ahead, Andy.
Yeah, thank you guys. Hope to get some honest feedback and see how we're doing here. Ways we can improve these things, just like Sean said. So thank you everybody for your time and listening to us for an hour today.
All right, take care everybody. Have a great day, and we'll talk to you soon.